I hope that this finds you well. I am joined today from the FSCA by my colleagues, Ms. Zinke Ngobo, our senior analyst in the team, Mr. John McKay, specialist analyst in the team, Mr. Mfariseni Ndou, senior analyst in the team, Ms. Mabatu Dibakwani, analyst in the team, and Mr. Abdurazak De Jong, who is also an analyst in the team. And later on, we will deal with data management and maintenance of records with our specialist analyst, Ms. Kekelezo Telejani. So today we will be taking you through the recently published Conduct Standard 2 of 2025. And this standard prescribes the various conditions in respect of retirement fund benefit administrators. And it replaces Board Notice 24 of 2002. For the past 23 years or so, administrators operated under this old board notice. It was therefore time to modernize the supervision of retirement fund benefit administrators. Conduct Standard 2 of 2025 came into effect on 6 August 2025, with some parts taking effect at various stages as contained in the standard. We will try to deal with every section with various presenters taking us through various topics. Before we do that though, and just to provide some context and to explain further on why it was necessary to issue the conduct standard. One, as explained before, we were really dealing with an outdated regulatory framework to supervise benefit administrators, and Board Notice 24 of 2002 did not reflect recent regulatory developments such as the Financial Sector Regulation Act, which established twin peaks and a principle-based manner of supervision, and the various TCF principles which guide our work. We therefore needed to move away from a rule-based approach to a principle-based form of regulation. Secondly, there was a lack of alignment with modern governance requirements. So the old board notice could not assist us in dealing with various industry challenges, from conflicts of interest that we were seeing in the industry, lack of adequate board oversight, digital data management issues, outsourcing problems, fitness and propriety issues, and various other governance issues. So the standard also provides good guidance and improved requirements for administration and service level agreements. It sets out clearly the rights, expectations, and responsibilities of each contracting party. And last but not least, it establishes the requirement for a complaints management framework, which guides on how complaints must be handled and must be dealt with, and how they should be escalated. So in all of these issues, the role of the board or the governing body is also emphasized in terms of their governance responsibilities. My colleagues will touch on all of these issues in their presentations, as well as on the management of trust accounts, suspense accounts, amongst others, the management of data and records, and also the operational ability requirements that have been prescribed for retirement fund benefit administrators, which includes administration system requirements and so forth. So not to steal their thunder, I'm going to hand over to them now to take us through the conduct standard. I hope that you have a great presentation ahead, and thank you very much for making the time to watch this. I will now hand over to Zinke to start. Thank you.
Thank you so much, Andy, for taking us through the overview of the training so impeccably. My name is Zinhle Ngobo. As Andy has said, I will be taking you through part 2 up to part 6 of the conduct standard. Part 2 of the conduct standard deals with governance and business principles. This sets out the behavioral function. Part 3 of the conduct standard deals with changes in business information. Business information, it has small, the part is very small, but it is very crucial. I will move over to part 4 and 5, which deals with key persons and fit and proper. This deals with who drives and ensures compliance, and then move over to agreements, which deals with how we structure relationships with administrators. I will start with part 2, which is found in paragraph 2 of the conduct standard, which deals with business principles. This states that administrators must aim for fair customer outcomes. This is famously known as treating customers fairly. And this is treating funds, treating members, treating beneficiaries fairly. Administrators must conduct business with transparency, honesty, fairness, integrity, due skill, care, and diligence. Administrators must also maintain effective management and educate control environment. Administrators must also be open, accountable, have cooperate engagements with the authority. This speaks to engagement meetings that we have with administrators. It also touches on annual meetings, thematic reviews, desktop reviews, and also it touches on information that we request from administrators. This means that each and every information that we request from administrators, it must be given in a clear format, it must be timely, it must be accurate, it mustn't mislead. And also, we also speak against barriers for termination of agreements. So if there is a termination, there mustn't be barriers. If there is an administrator or members that want to lodge a complaint, there mustn't be any barriers for lodging of complaints. Under the old board notice 24 of 2002, there were no provisions. And then I will move over to paragraph 3 and 4, which speaks to the obligations of the governing body and governance arrangements. Administrators must be accountable for compliance with the standard. This speaks to the oversight of the establishment, implementation, monitoring, ongoing compliance of its governance arrangements. They should also adopt, document, implement and monitor and review the effectiveness of governance arrangements that provide for the prudent management and oversight of its business. Under the board notice, no provisions were made. I must emphasize that governance is not just a tick box. It underpins the decisions that are made and how these risks are managed and how obligations are fulfilled. I will now move over to part 3, which deals with notifications regarding changes in business information. The conduct provides that changes such as business trading name, registered address, postal address, contact details. These changes must be communicated within 30 days with the FSCA. So the objective of this exercise is to keep the regulator informed and up to date so that when we do our supervision, then we are able to liaise with administrators in a correct format, in a correct platform. We also would like to emphasize that if there are any changes with the business trading name, registered address, postal and contact details, these changes must be uploaded on our FSCA e-portal system. So each and every administrator's responsible person has login details. So they just log onto our portal and then they update these changes. And again, I will emphasize that this should be done in 30 days. I will now move over to part 4, which deals with the key persons. Classification of key person as set out in paragraph 6 is governing body, which is directors, senior management, and head of control. Under the board notice 24 of 2002, there was no provision in this regard. And then I will also move over to the notification requirements. The benefit administrators must notify the FSCA within 30 days of key person's appointment or termination. And then when it comes to the FSCA's oversight, in case of a termination, reasons must be provided. And also, the FSCA has the right to object to any appointment if the candidate doesn't satisfy the fit and proper criteria, violates the Pension Funds Act, or isn't contrary to public interest. Administrators must ensure that they do due diligence before appointing any key person, and they must also ensure that continuous monitoring of their key person is done. Under the board notice, there was no provision that was made. I will now move over to part 5, which deals with fit and proper requirements. The fit and proper requirements, this is the foundational part of the standard. It ensures that all those who hold significant responsibility meet high standard and integrity and competence. Paragraph 7 deals with general fit and proper obligation. Benefit administrators and their key persons must at all times comply with fit and proper requirements as prescribed. Paragraph 8 deals with honesty, integrity, and good standing. This means that any indicators that constitute prima facie evidence that this requirement is not met, compliance by benefit administrators should be evident in corporate conduct. The FSCA also assesses the seriousness, surrounding circumstances, relevance of conduct, and elapsed time since the incident. Paragraph 9 deals with competence. Key persons must have adequate, appropriate, and relevant skills, knowledge, expertise, educational qualification, and experience aligned with the function that they perform. I will now move over to paragraph 10, which deals with non-compliance redress. Where a key individual fails the fit and proper requirements, the FSCA may direct the administrator to arrange to address the non-compliance. Such interventions may be training, suspension, outsourcing, removal, or other corrective steps. Administrators must cooperate and may need to take action in response. I will now move over to agreements in respect of administration services. Paragraph 11 states that before providing a service, a benefit administrator must enter into a written administration and service level agreement with the fund. Administration agreements outlines the scope and the administration services, remuneration, termination procedures, outsourcing, and the compliance function. Requests from the funds must be made available timelessly. When we refer to timelessly in this regard, we are referring to 7 days. Termination requires at least 90 days written notice. For existing agreements that were entered into prior to the conduct standard, they must be revised to comply within the implementation period. SLAs should also include timelines, administrative procedures, communication channels, review procedures, including frequency. And then we move over to paragraph 12. As we all know, that good things do come to an end. So there are new relationships that are entered into, and some relationships come to an end. So it is very much important that we plan for terminations because they might happen in business. So paragraph 12 states that on termination of an administrative agreement, the FSCA must be notified within 30 days. And then administrators must transfer records data within 15 business days after the effective date. These records include reconciliations, unresolved complaints, any other supporting data must be provided to the new administrator. Records and data must be provided in an electronic in an electronic format that is agreed upon and that is compatible. Under the board notice 24, the administrator had to furnish a report to the registrar within 14 days after the completion of termination. So now with the conduct standard, we are saying that the transfer of information and data must be done within 15 days after the effective date. Thank you very much, colleagues. I will now hand over to my colleague, John, for him to take you through outsourcing. Thank you.
Thank you, Zinhle. I will be taking you through paragraph 13 up until paragraph 19 of the new conduct standard. Paragraph 13 deals with the outsourcing, and together with paragraph 14 and paragraph 15 deals with the conflict of interest management, and paragraph 16 deals with the communication and disclosures of benefit administrators, whereas paragraph 17 up until 19, they deals with complaints management framework. So paragraph 13 requires that when there is an outsourcing agreement, the outsourcing agreement should be between the approved benefit administrators. In other words, those two parties should have been approved as a 13B administrators, and they should be entered into for an administrative service. And when we talk about an administrative service, we are talking about we are referring to receipt of contributions, and disposition of benefits. So it is also imperative that the administrator that is outsourcing remains accountable for any service that is outsourced. That administrator also that outsources, it must ensure that its customers, referring to the funds and the members, ensure fair treatment from the other administrator. It must also remain the decision-making authority over the other administrator. So the other administrator, which is I'll call the outsourcing administrator, this administrator must have outsourcing administrator. It must have the capacity and ability to perform the administration services. It must be able to comply with this conduct standard. In other words, because it is an approved 13B, it must comply with the standard as it is. And in all this, it's imperative that there must be an outsourcing agreement which must be clear and provide the roles and responsibilities provided in the admin agreement. Paragraph 14 deals with management, oversight, and review of outsourcing agreement. In other words, who manages and oversees this agreement? The conduct standard states that the outsourcing agreement must manage, the outsourcing administrator must manage and oversee this agreement. The outsourcing agreement must be reviewed regularly to assess the outsourced services. This may include issues around data protection, treatment of customers, and implementation of processes and procedures for services provided. Paragraph 15 deals with conflict of interest management. The administrator is required to have this policy in place. This policy supplements the requirements contained in Section 13B(5)(a) of the Pension Funds Act, which talks about the avoidance of conflict of interest by administrators. Again, this policy must be reviewed regularly and also be made available to staff members. The policy must disclose any potential conflict to its customers. For example, where officials of a fund or benefit administrator are doing business with each other. There must also be training afforded to staff for recognition and handling of conflict of interest. Paragraph 16 deals with communication and disclosure. Also, this is a new inclusion in the conduct standard. It was not part of the board notice, the previous board notice 24 of 2002. So the conduct standard states that before, during, and after the conclusion of admin agreement, the administrator must disclose all relevant facts that the fund should be aware of to influence its decision relating to the provisions of the services by the administrator. This should be done so that the service provider can take an informed decision. The communication, therefore, must be clear, it must be accurate, and not misleading. It must also be in plain language and accessible to all members. Paragraph 17 deals with the establishment of a complaints management framework. This also is a new inclusion in the conduct standard. It was not covered in the previous board notice. The conduct standards state that the administrator must have this policy in place. This policy must be accessible to stakeholders and members. Usually this is done via websites or upon request, as and when they are requested by the customers of the administrator. The governing body of the administrator must approve and oversee this policy. And also this policy must be reviewed regularly to remain relevant. Paragraph 18 deals with the requirements for complaints management framework, which amongst others mentions that the policy must clearly define and purposes and goals implemented by the administrator. It must specify the roles and responsibilities of individuals dealing with complaints. It must outline processes and procedures for receiving, investigating, and resolving complaints. There must be an escalating process and measurable timelines for resolving complaints. Again, this policy must be monitored and reviewed regularly. Paragraph 19 deals with allocation of responsibility. Who is responsible? The governing body is responsible for this policy, that is the Complaints Management Framework Policy. The roles and responsibilities must be assigned to appropriate staff, that is staff with relevant skills, relevant training, experience, knowledge. And this brings me to the end of my presentation. I will hand it over to Mr. Ndo. Thank you.
Afternoon, colleagues. My name is Ndo. I'll be taking you through paragraphs 20 to 23 of part 9. Provisions of these paragraphs were not addressed in the board notice. Paragraph 20 is complaints escalation and review process. This paragraph was designed to ensure fairness transparency, accountability when handling complaints. Benefit administrators must have a proper internal process for escalating and reviewing complaints. The process must be accessible to all complainants. The process should be simple and not require any excessive paperwork or administrative effort from complainants. Complainants must be allowed to escalate complaints if they are not satisfied with the initial resolution. The review process must be handled by a senior impartial person within the benefit administrator or someone appointed especially for the role. Paragraph 21 is decision relating to complaints. This paragraph ensures that customers are treated fairly throughout the complaints process, and it also encourages financial institutions to improve internal dispute resolution mechanisms. If a complaint is upheld, the benefit administrator must act promptly to fulfill any commitments like compensations, goodwill payments, or any other remedial action within the agreed timeframes. If a complaint is rejected, the complainant must receive clear and sufficient reasons for the decision. All decisions must be carried out promptly and in accordance with the administrator's internal complaints management framework. Paragraph 22. This one is record keeping, monitoring, and analysis of complaints. This paragraph reinforces the FSCA's TCF principles by ensuring that complaints decisions are handled with transparency, accountability, and fairness. Benefit administrators must ensure accurate, efficient, and secure recording of complaints. This applies to all complaints received and handled by the administrator. Records must be protected against loss, unauthorized access, and tampering. Records Paragraph 22, which is record keeping, monitoring, and analysis of complaints. Records must be readily available for inspection by the FSCA. Data must be used to monitor trends, identify risks, and improve complaints handling process. Records must be retained for a minimum of 5 years or as specified by the law. Paragraph 23 is communication with complainants. This paragraph is important because it ensures that complainants feel heard, respected, and informed throughout the resolution process. The complaint process and procedures should be clear and open, ensuring that complainants fully understand how their complaints will be managed. The complaint process should be easy to find, clearly visible, and simple for customers to understand. Complainants should be regularly informed about the status and progress of their complaints. Administrators should communicate through methods that suit members, such as emails, phones, and online platforms. Colleagues, this brings us to the end of my part. Thank you so much. I will now invite Keke to talk us through her part. Thank you.
And I will be taking you through part 10 and part 11. So, which is from paragraph 24 to paragraph 29. So, data management and maintenance of records. in this section, benefit administrators focuses on how to manage data, maintain records, and safeguard fund asset administration to ensure transparency, member protection, as well as regulatory compliance. So under paragraph 24 specifically, paragraph 24 focuses on data management under conduct standard as compared to previous framework. So in this section, benefit administrators are required to maintain proper data governance framework. So they must implement documented strategies, policies, systems, and controls for managing data. They must also ensure data quality standards, which means that data must be accurate, reliable, secure, complete, and also accessible. So for outsourced data, they must ensure continuous access to data held by third-party service providers. So this is to ensure oversight and accountability. And data management framework must be reviewed regularly, so at least annually. So these aspects were not addressed under Board Notice 2024. So overall, the emphasis under paragraph 24 is on strong data governance to reduce operational risk and also protect sensitive information. Next slide, please. Okay, and now moving on to paragraph 25, which is maintenance of records. So the key point here is that record keeping requirements are now more broader and structured. So benefit administrators must have proper systems, processes, as well as procedures in place to maintain the records of communication with funds and members, transactions, instructions received and executed, as well as any other relevant documentation. And records must be in electronic or printable format and must be accessible and retrievable. And under Board Notice, as we can see, the focus was only on documents of titles, asset registers, minutes books, and also there was no format requirement, but only assumed physical custody. Next slide, please. Again, another requirement under a maintenance of record is ensuring proper protection of records while meeting access obligations. So benefit administrators must also implement controls to prevent loss, destruction, or unauthorized access. And the records must be made available to the FSCA, the fund, members, or other entitled parties upon request. And also under Board Notice, the protection of records was not addressed, and benefit administrators were only required to deliver records to the board or new administrators upon cessation. So this matters as secure records protect sensitive member and fund data, while accessibility supports transparency and regulatory oversight. Next slide, please. Okay. So this part, paragraph 26, the emphasis here is strong governance and protection of member and fund assets records. So under conduct standard actually clarifies that if the administrator receives or holds documents of title on behalf of a fund, it must maintain a register including details of ownership, because and those details must be accurate and up to date. So under board notice, the register was required, but accuracy was not emphasized. And accessibility, access and availability. So conduct standard explicitly requires documents of title and registers to be accessible to funds and FSCA upon request. So accessibility was generally required under board notice, but it was not clearly articulated. And also, conduct standard enforces controls to prevent loss, destruction, or unauthorized access for documents and registers. So this clearly indicates a focus on safeguarding of assets, which was not specifically addressed in the previous framework. And lastly, conduct standard also strengthens exit arrangements. So upon termination of agreement, documents must be securely transferred to the fund or new administrator, and submit confirmation letter must be submitted to the FSCA. And under board notice, the reliance was only on auditor confirmation. So there were no proper transfer of controls. So in essence, the conduct standard moves from basic record keeping to a stronger governance framework. This brings me to the end of part 10, then part 11, finance matters. Okay, finance matters. So this section ensures that benefit administrators are financially sound. They are able to meet short and long-term obligations. So benefit administrators must maintain full and proper accounting records on continuous basis under conduct standard. So this is very crucial because the accounting records that are updated monthly can give an indication or early indication of financial risk. And risk is one of the key areas of focus under supervision. So on board notice, there was no frequency. The information was only provided on annual basis. And they must also provide annual financial statements in accordance with accounting standards, as compared to board notice 24, where administrators were only providing annexures. So this is very important, as annual financial statements gives a clear direction of where the entity is going financially. Next slide, please. Okay, paragraph 28, appointment and termination of auditor. Benefit administrators must appoint an auditor registered under the Auditing Professions Act under conduct standard to audit annual financial statements. And the scope of an auditor must only focus on auditing annual financial statements as compared to the previous framework, where the scope was different. The auditor had to assess compliance, fair presentation of financials, appropriateness of accounting systems. Next slide, please. And now moving on to notification to authority. So benefit administrators must notify the FSCA within 30 days of appointment of an auditor, including auditor's letter of acceptance. And they must also notify the FSCA within 30 days of termination, in case of termination, with proper reasons for termination. And these requirements were not addressed under board notice. So this is one of the most important requirements, again, under conduct standard. Please move to the next slide. Okay, and now, last but not least, the submission of annual financial statements to the authority. So this section outlines the documents required, content of management letter, as well as submission deadlines. So under conduct standard, audited financial statements as well as management representation letter must be submitted to the authority from the governing board, which is directors in this case. And the management must confirm the review of records, fair presentation, as well as compliance with legislation and conduct standards. And under board notice, these requirements were not addressed again. So the management was confirming number of funds, fidelity and PI covers, as well as the change in control. But now the requirements are more detailed to give a clear picture of the entity. And the submission deadline is within 6 months. So within 6 months after year end, benefit administrators must submit annual financial statements to the authority. Thank you so much, colleagues. My presentation ends here, and I will hand over to my colleague, Abdurazak. Thank you.
And I'll be guiding us through the remaining paragraphs of Part 11 and then proceed to introduce Part 12, the conduct standard. So paragraph 31 introduces detailed requirements for trust accounts. These accounts must now be interest-bearing and held with a registered bank. Contributions must be allocated to the correct fund or sub-fund within 2 business days. The board notice allowed trust accounts, but did not specify that they had to be interest-bearing or set any allocation timelines. The new conduct standard also introduces clear procedures for unallocated contributions. They must be investigated within 2 business days and if still unresolved after 30 days, reported to a senior manager and the fund. Overall, these updates ensure faster allocation, tighter oversight, and better protection of members' assets. Next slide, please. Through paragraph 31, the conduct standard also introduces stricter reconciliation and payment requirements with regards to trust accounts. Benefit administrators must now perform daily reconciliations reviewed monthly by a senior manager, with any reconciling items resolved within 7 business days. Under the board notice, only an annual audit of the trust account was required, meaning discrepancies could persist for much longer. The timelines for payments have also changed. Rejected payments must be returned to the fund within 2 business days, and payments to beneficiaries must be made within 2 working days of deposit into the trust account, compared to the same-day requirements under the old framework. Lastly, any interest earned on unallocated funds must now be included in the payment to the fund once those funds are properly allocated. This ensures that members receive the full benefit of interest earned during the holding period. Apart from the trust account management, the conduct standard also introduces a completely new concept, the handling of unclassified payments and suspense accounts. Paragraph 32 introduces a new framework for handling unclassified payments. When a payment cannot be immediately classified, it must be investigated without delay. If it remains unresolved after 3 business days, it must be transferred into a suspense account. All suspense account balances must be reported monthly to a senior manager and quarterly to the governing body, ensuring continuous oversight and governance visibility. The previous board notice contained no equivalent provision, so this is a completely new layer of control and accountability introduced by the Conduct Standard. Now that we've covered trust and suspense accounts, the next requirement focuses on risk protection, ensuring administrators have adequate insurance in place to cover potential losses or misconduct. Paragraph 33 requires benefit administrators to maintain professional indemnity and fidelity guarantee insurance, with coverage determined by the benefit administrator according to the complexity and scale of its business. Benefit administrators must also disclose to the fund any self-payment gaps or material exclusions in the cover. Under the previous board notice, the level of insurance was set by the auditor and the registrar, i.e. the FSCA, and there were no additional disclosure requirements. The new approach shifts responsibility to the benefit administrator, promoting self-assessment, transparency, and greater fund awareness of insurance adequacy. Next slide. Now we will be touching on part 12 of the Conduct Standard that deals with financial soundness and operational procedures and controls. Paragraph 34 sets out financial soundness requirements. Benefit administrators must maintain current assets greater than or equal to current liabilities and liquid assets equal to at least 8/52 of annual expenditure. The definition of liquid assets now includes money market instruments, offering more flexibility for administrators. If subject to other financial legislation requirements, benefit administrators must comply with the most onerous rule. These updates modernize and harmonize liquidity expectations. In summary, paragraphs 30 to 34 ensures that benefit administrators manage these special accounts responsibly, safeguard members' assets and under the new Conduct Standard, and maintain the necessary financial capacity to operate their businesses effectively. I will now hand over to the next presenter, Mabato, for the remaining paragraphs.
Thank you, Zach. I am Mabatoli Bagwani, and I will be taking you through paragraphs 35 to 39. So I'll be starting on part 12, which is the second part of So I'll just be doing the last bit of the paragraph 12, which covers operational ability. This paragraph introduces formal operational standards. It indicates that an administrator must have operational resources in place, meaning have adequate human, technical, and technological resources to perform administrative services effectively. The board notice 24 did not cover the requirement for operational resources. However, Section 13B5 of the Pension Fund Act covers this briefly on the operational resources. Over and above having the operational resources in place, the administrator is required to establish appropriate operational procedures and controls relating to all the aspects of the administration services. This is to ensure services are delivered timelessly, accurately, and effectively. This paragraph also covers the administration system that the administrator has in use. Basically, what this means is that the administration system in use should have functionalities that allows the administrator to timelessly and accurately render administration services, maintain accurate and complete records, properly communicate with members, and lastly, to enable the administrator to do legal and regulatory reporting. Next slide, please. Okay. Sorry, just go back. Okay, thank you so much. So I'm still on paragraph 35. So the standard requires the administrator to notify the FSCA before replacing or migrating administration services, and also to confirm that the new administration system in place complies with the operational standards. The administrator must also inform all the funds that might be affected of any material changes to the administration system, and the administrator should ensure that this is done in a timely manner. Also important to note, the administrator must maintain maintain a contingency plan for disaster recovery and periodically test backup facilities to ensure continuity of its business. Next slide. I'll be moving over to part 13 that covers mergers and acquisitions. Paragraph 36 on mergers and acquisitions requires FSCA approval for any merger or acquisitions involving benefit administrators, and it also requires the benefit administrator to conduct due diligence on the target administrators, including fit and proper checks on key persons that would include directors and senior managers. This paragraph also notes that where applicable, the involved parties must obtain approval from other relevant authorities. In this case, an example is the Competition Commission. Also important to note is that failure to obtain approval from the FSCA renders the merger or acquisition null and void. As we would note, the board notice did not have any provisions on the mergers and acquisitions at all. Next slide, please. And then moving on to paragraph 37, which covers ceasing, dissolution, or liquidation of business. Basically, this is for when an administrator intends to cease business or liquidate or dissolve its business. So paragraph 37 requires the administrator to inform all affected funds under its administration of its intention to do so and transfer all data in its possession to the new fund or administrator in a case that a new administrator has been appointed. The administrator is also required to submit a report to the FSCA in the form of a letter within 90 days after ceasing to perform administration services, confirming compliance with the transfer of data, records, and notification requirements. So previously, this was done in terms of condition 13 of Board Notice 24, whereby the auditor had to submit a report to the registrar confirming delivery of records and identifying the recipients of those records, but it did not require the direct fund notification and had no specified timelines for the delivery of those records. Next slide. Moving on to paragraph 38, which is on suspension or withdrawal of approval as a benefit administrator. So paragraph 38 covers suspension or withdrawal of approval as a benefit administrator, and it indicates that if the FSCA intends to suspend or withdraw approval, the administrator must notify all funds of that intention of the FSCA to do so. And in the case of an approved suspension, the administrator may not enter into any new agreements until the suspension is lifted. So this was previously not covered in the Board Notice 24. However, Section 13B6C would apply in such cases, as it also knows that the administrator may not provide new or additional services to any funds while under suspension. So this section of the Pension Fund Act is aligned with the paragraph 38 of the Conduct Standard. Next slide, please. Thank you. Moving on to part 14 on administration. So this is on paragraph 39, which covers determination of manner, format, content of notification, and approval applications. So in paragraph 39, it gives the FSCA authority to prescribe the format and content of notifications and approval application via its website. This paragraph basically allows the FSCA to update formats dynamically without amending the conduct standard. So previously, the board notice had applicable forms that were directly embedded in it. They were fixed formats for reporting and notifications. These were in the form of annexes A to D that were previously used in terms of the Board Notice 24. So this paragraph 39 replaces the static annexures of Board Notice with a more flexible system that allows the FSCA to respond quickly to new compliance needs and industry changes. Next slide. Oh, we have reached the end of our presentation. Thank you so much for your time and attention.
Okay, thank you very much. Thank you so much, colleagues, for such a wonderful and insightful presentation. It is really appreciated. So should anyone watching wish to ask a question, should you have any question on any of the slides that we displayed or any paragraph that was covered in the presentation, please note that we will be putting a contact list as part of this upload of the webinar. So feel free to engage with the analysts that were doing the presentations, and make sure that, you ask whatever clarity seeking questions that you may have. I just wanted to remind you as well that the standard was actually published with some forms. So please refer to FSCA Notice 10 of 2025, because there's various forms that must now be used in line with the conduct standard for you to notify us of various items. For example, we've got Annexure 1, which deals with business information. So if you wish to change your business information or notify us of any changes, please complete paragraph 5, Annexure 1. And we also have Annexure 2, which is linked to paragraph 6 of the conduct standard, which deals with notifications for the appointment or termination of a key person. So if you're changing your responsible person or person in charge, we now call them key persons, please notify us and use Annexure 2. We've got Annexure 3, which deals with notice of termination of administration agreements. When your administration agreement is terminating, you need to notify us. Please look at that annexure. We've got Annexure 4, which is a report regarding the termination of an admin agreement. So you'll see that's a 12.1C2 annexure that has to be completed. So everything is linked to a paragraph of the conduct standard. So if you look at the schedule, you will be able to link each form to the requirement in the conduct standard. We've got Annexure 5, which is the registrar of assets or a register of assets held on behalf of a pension fund that must be kept, and it should be produced upon inspection. We've got Annexure 6 as well, which deals with mergers and acquisitions. So thank you so much. I think that's it from our side. Thank you so much for watching, and thanks to my colleagues as well. All of the best, everyone. Thanks. Cheers.